Hello. On the 24th of March, Judge McGill of the District Court of Queensland handed down a judgment, Vickers and Pickering, that I think has some interesting features that those involved in family provision claims should take note of. The application itself was for the summary dismissal of a family provision application on the basis that it was made out of time in circumstances where the estate had been substantially distributed. The circumstances were that there had been negotiations going on between the intended applicants and the executors, but when the 9 months was up, a distribution of substantially the whole estate was made. In the event, Judge McGill considered that the application itself for summary dismissal should be dismissed, and in fact ordered costs personally against the executor and described the executor's conduct in the circumstances as disgraceful. Harsh words indeed, of course. Now, the basis of his decision was that he believed there were a number of arguments that the applicants could make that might result in them being successful in the claim. The three were these: that under Section 8 of the Trusts Act, an order could be made to require the beneficiary to return the distribution to the estate using the powers under that section. There could be an argument about estoppel in the circumstances, the ongoing negotiations and so on. And the third was whether, in fact, under the terms of the legislation, you could say that the estate had been properly distributed. He commented that there had been no particular judicial determination about what those words meant, and he thought that it was arguable that in these circumstances it may not be a proper distribution. What happens with those arguments in the course of another judge considering it, or even in this case, remains to be seen. But at least they've been identified as potential arguments, and I think it's important that we take them all on board, because it may no longer be a quite simple exercise that if the estate's been distributed as we would normally expect to give a closure to the matter, there could be arguments that could open it up again. Well worth a read. Thank you.